It's a delight to have you join us here on ITV for Law and You. We appreciate that. I'm Uyi Agumofwegbe. I'm coming to you from Benin City in Nigeria. In the last 2 weeks, thereabouts, the discussion around suspended acting chairman of the Economic and Financial Crimes Commission, Mr. Ibrahim Magu, had been essentially the talking point across this country. One of the concerns expressed was that in the first instance in 2004, the Economic and Financial Crimes Commission, that is the EFCC, had been established by the then Obasanjo-led administration to address squarely issues of corruption, particularly financial corruption. As a matter of fact, there's an act, which means there's a law establishing the commission and all of its activities. So that is settled. Several years down the line, this is 2020, 16 years down the line, a lot of persons are still scratching their heads and probably asking what exactly has the commission achieved, and what exactly is even the focus or should be the focus of the commission in the first instance. There are also those who are asking whether or not the EFCC has become more of a problem than the issues it was set up in the first instance to address. My guest of the program today is a lawyer and would help us take a professional look at the act establishing the EFCC. Stay with us. Now let's begin this discussion, everyone. It's a pleasure to have you join us, Barrister Peter Ejiofor, here on Law and You this wonderful day. I know you, being a Nigerian, you're also concerned about all of the, as it were, drama surrounding the, not just the EFCC, but the person of the suspended acting chairman of the Economic and Financial Crimes Commission. I want us to begin setting, as it were, the perspective for this conversation by looking at the capacity in which he served prior to his suspension. He was in acting capacity. There are lawyers like yourself who argue that in an ideal circumstance, there was no way he ought to have been there for more than 3 months in acting capacity. But we also understand that the man had been sent back time and again to the National Assembly for confirmation by the president. Of course, we are aware that he was rejected. Is the law silent on these issues?
First of all, we have a constitution in Nigeria, a substitute constitution that have addressed to a large extent these arguments. We also have, flowing from the constitution, the Act of the National Assembly establishing the EFCC as an agency of the federal government of Nigeria. And so, to that extent, looking at the laws, we shouldn't even be having all these conflicts. I think it has to do more with personality than the law, the existing law, as it were. That is the position.
Having said that, then you have the concern about the conflicts that we have come to realize does exist, or at least did exist, between the suspended acting chairman of the EFCC and the office of the Attorney General of the Federation. There are two prongs to it. On the one hand, you have those who are saying the president being his principal, he should be the one to whom he reports. In other words, Magu, while acting as the chairman of that commission, should report by all means to the president because that is his principal. Others say, no way, the law has already made it clear enough that he reports to the office of the Attorney General, who, of course, doubles as the Minister of Justice, because there's the interpretation of the law that the Minister of Justice in Nigeria is the supervising minister of all the anti-graft agencies. Help us make legal sense of that.
Yes, the Constitution, first of all, stated that the National Assembly, Section 4 of the Constitution of the Federal Republic of Nigeria, 1999, as amended, stated clearly that it is the National Assembly that has the powers to make law for the good governance, peace, and order in Nigeria. So, to that extent, these laws, as they exist, are meant to be a sort of guidance to us. The Act of the National Assembly, you know, before we exited the military regime, we came into the civilian government. We now have a situation where the Constitution has been amended severally. And the amendment, to that extent, we expected going forward those amendments would have at least cured or to a large extent removed all these obstacles that we are seeing. But it appears that we still need to do a lot of progress going further. The Constitution itself, Section 150, established or provided for the office of the Attorney General. The Attorney General, at the same time, is also the Minister of Justice. So he occupies two positions. He is the Chief Law Officer and then the Attorney General of the Federation. Section 150 having made the provision, Section 174 of the Constitution goes further to itemize or state the powers, duties, and responsibilities
of that office
of the Attorney General. That's clear enough. I have explained to you before, I have explained here that the National Assembly have the powers to make laws for the federal government under the exclusive and concurrent legislative list. Now, the Constitution, having empowered the National Assembly to do so, they have by so doing enacted a law, now an act, establishing the Economic and Financial Crimes Commission. So there is clearly no conflict there, because flowing from this Constitution, exercising the constitutional power, the National Assembly have created this body. This body, from the creation, if we look at Section 171 of the Constitution, states who are those who are to be appointed by the President, and under which circumstance those persons should be confirmed by the Senate before they begin to function. It appears that there is no clear-cut or explicit provision for the EFCC as an agency. Rather, where you will find the provision for the EFCC is under a different section that refer to them as extra-ministerial departments. Under the extra-ministerial department, under that provision of 171 of the Constitution, there is no provision that such persons who are so appointed to that position should be presented to the Senate for confirmation. In that case, it becomes superfluous for the President, for instance, to go forward and present Mago for confirmation.
So was that a fundamental error in the first place?
Yes, it was not a flaw. Conventionally, it has been the practice to present certain persons in certain positions
after nomination,
for
so they can be
screening
confirmed
and confirmation. I think it is a good practice itself. If we want to look at the rigidity of the law and follow it strictly, there was no need for him to be there in the first instance. But there is another school of thought who I also respect that says that he ought to have appeared and before the National Assembly, this time around the Senate, for confirmation. But they cannot ground that argument under any provision of the Constitution as it is. So when the Vice President at that point in time when the issue arose was making the argument, as a professor of law anyway, that there is no clear provision that says that the President must present the EFCC chairman to the Senate
as a nominee
for screening and confirmation. He was on the right track when he made the statement.
In the eye of the law?
Yes, in the eye of the law, was on the right track. Because positions under Section 171D and E, subsection 1 of 171D and E, under those provisions, there is no provision mandating the President to present such persons for screening or confirmation.
Is it therefore safe, for example, to say that probably was the basis on which the president allowed him free reins beyond the 3 months, 3-month period.
I'm coming because you have those who are his personal officers who work under him.
Right.
They work at his pleasure. He has the power to appoint them and dismiss them. Somebody like the head of service, somebody like the what do you call, the secretary to the government of the federation, the chief of staff, for instance, not head of service. I'm talking about chief of staff, the secretary to the government and all that.
Right.
Those ones are his appointees.
So he has prerogative.
Yes. Those personal assistants and advisors, they are his appointees. He has a prerogative. And going forward, under section 171, subsection 1E, the extra ministerial departmental heads could be appointed by the president without reference to the Senate for confirmation, screening or confirmation. It happens that this is one of the grounds that the vice president was emphasizing when he said that the MAGU ought not to have been presented in the first instance to the Senate for confirmation.
So going forward, I mean, events have obviously overtaken that incident.
If you now look at my a little explanation now, you will now know that who is this person now answerable to?
Between the Attorney General of the Federation and the President who appointed him in the first instance.
Yes. Since I said, I've just explained to you that there is no
clear
direct reference to the EFCC under our Constitution right now.
Yes.
That you can find that under section 171.
Categorically.
You can. You can. But if you now look at the chain of command now, you know that this person reports to
his principal.
He reports to who is appointed. Assuming
without recourse to the AGF.
Yes. Without recourse to the AGF. That is the gap, the missing link. But that is not to say that there is no provision in the Constitution that incorporates the office of the AGF or the ministry in the EFCC Commission. Members of the Commission, a member of the Ministry of Justice, Finance and other agencies, including even the Governor of Central Bank, representative from so many other agencies, the military, the police, are members of the commission. They are appointed by the president as members of this commission. You can see that the composition at least allows some degree of flexibility for there to be a liaison between the Ministry of Justice and the commission where there is even any issue that will arise. That was why I was telling you that whatever could have been given rise to all these arguments that is now in the public sphere is personal issue because the Constitution is clear enough.
There are those who argue that MAGU in particular, amongst all the executive chairmen, whether substantive or acting over time, had become so powerful. How much of power really does the Act confer on the holder of that office, I mean the executive chairman of the EFCC?
Yes, the power conferred on the executive chairman or the commissioner is very, very enormous.
Okay.
It's very, very enormous. In fact, if you go to section 6 of that act, you will know that this man could just see you walking the street and look and say, this man, you are living above your means. Or maybe living in a house and say, this man, we have to investigate you. We investigate and find out how you came by this. If this thing is beyond your source of income, we can prosecute you. He has that power to that extent in Nigeria. So he has the power. They are the ones that administer issues that are relevant to the Money Laundering Act, the Bank and Other Financial Institution Act, the Failed Bank Act, and so many other provisions, the Advanced Fee Fraud Act. It is under the EFCC.
Directly under the EFCC?
Yes. So you imagine, just look at all those laws and begin to look at the powers given to the agency to manage or to prosecute under those acts. You know that they are very powerful.
There are people who have argued over time, a good number of them being lawyers like yourself, that we are doing so much of, there's a proliferation sadly, they say, of anti-graft agencies. They're saying, for instance, long before now, we already had the NFIU. We already had, for example, a few other agencies of government saddled with the responsibility of checking corruption of whatever nature, including financial crimes, for instance. Is it too much? They say the more the merrier. So was it too much when the federal government at some point decided to bring on the ICPC and the EFCC?
Well, you know, this EFCC came as a kind of based on necessity of that moment. The government at that time felt that corruption was on the rise, and they want to do something about curbing corruption. The international agencies and other governments also felt that Nigeria was immersed in corruption, and they were trying to see how we could key into the international best practices to see how we can bring down corruption in Nigeria. And so, because we don't live in isolation of the global community, it became necessary at a point that Nigeria must key into the process of eradicating corruption. Of course, you know that the international institution like the Finance Action Task Force is an international agency established in 1989 in Paris that is empowered to track money laundering at international level, money that is used to fund proliferation of arms, weapons and arms,
terrorism,
money that is also channeled to fund acts of terrorism. Those are the area the agency is empowered. So as it was growing, they made so many recommendations. It became necessary that state parties who are members of this organization must establish institutions that will also liaise with this international body to begin to fight corruption at this point. It was at that point that Nigeria was, it was suggested to the government then, and the government established the Economic and Financial Crimes Commission. At the point it was established, you know, why I was telling you that so many agencies and institutions are members of that commission is that along these lines, including the banks, along these lines you find that crimes of any nature internationally involving any agency or any department, whether the banks, whether foreign ministry, the EFCC will be involved because they are charged with economic and financial crimes in Nigeria. They are charged with the responsibility to fight it. So you know that crimes can be committed at any level. Obviously. And because this agency and the commission has all these persons representing it, whatever crime that has anything to do with the power of the EFCC has to come in. It is the same with international agencies. The Interpol and others are also members of the Financial Action Task Force that I'm referring to. The African Development Bank, the World Bank, they all have members representing them in this body. So the Nigerian government cannot exist or operate in isolation. That was why this was established in Nigeria.
We want to take a quick break now because we have to find a way to put the icing on the cake, in a manner of speaking, on this discussion on the program. We're back shortly. Do stay with us. All right, thank you for staying with us on the program. I was just going to make us look at something else before we're done, which is the issue of the acts that establishes established the EFCC. When we look at the realities in front of us today, vis-a-vis the law establishing the commission, do you think there are areas we have to take a second look at? I mean, the National Assembly now, to say, look, there are loopholes here that we didn't see 10 years ago, 16 years ago. Let's plug them. Do we have such areas from what you see?
Yes, we have. We can tinker with the Constitution to the extent of clearly defining how the EFCC chairman can be appointed, whether his appointment should be subject to the confirmation, screening and confirmation of the Senate as a National Assembly or not.
Yeah.
I think that has become something that we have to address. We also look at it. What is the relationship between the Attorney General of the Federation and the EFCC now? How does it go? Who gives the order? Who obeys? How does their relationship flow? Since there is this friction between the two agencies, but it is not only the AGF that is having issues.
Who else?
Only that it is more pronounced.
Okay, on that level.
The Nigerian police itself is having issues with it, even though that the Magu himself came from the Nigerian police. They also have issues with him. Many other agencies have felt that the man is over. Even the DSSS are also having issues. Even the DSSS report against him is damning. Ordinarily, it ought not to be there, based on the report. During the time of Waziri was investigated, and they found that there were some files that ought not to have been in his place. That was the information in public domain.
That reportedly were found in his private residence.
And so he ought not to have. If it was proven, what is he doing there? And secondly, now there is this second investigation that is going on now, and we don't know the outcome yet. I guess maybe by the time the panel finish their sitting, they'll be able to make their recommendation to the president, and let's see how it goes from there. But I think the president is conscious of the image of the government, and they are looking at it from the point that things cannot just continue like this. But I think there is this adage in our place that when you point one finger at somebody and the other four fingers are facing you, the Magu himself is also pointing a accusing finger at the AGF. That look, even you yourself, you are also involved in, you are immersed in corruption. It becomes a pervasive complication that we are grappling with in Nigeria. Because there is this report again that the AGF is involved in so much sleaze, including his families, and so who is now the hunter, and who is now being hunted? It appears the hunters in Nigeria are now being hunted too. While they are hunting, they are also being hunted.
Which in your words again makes it complicated. But there's something I want us to look at finally before we're done altogether. Does the Act specifically say the executive chairman of the EFCC must come from the police? I'm just wondering.
No, he said the Act only provides that it must be either a serving or a retired person from this circle, either the military, the police, the army, the national security agencies, the DSSS, anybody who is so qualified can be made the chairman. They didn't specifically refer, but conventionally we have been using the police. But I think in a way too, it is also good. If things go well, why should we have this argument? Looking at good governance and how to move the nation forward, people that are serving in the same government, in the same party, are fighting themselves. It's embarrassing.
I can imagine. Okay, Barrister Jafo had to get a bit emotional about that because he's a man who loves his country. But basically what we've done on the program this week is to look at the EFCC as an agency saddled with the responsibility of fighting graft in this country vis-a-vis the Act establishing it in the first instance. Again, Barrister Peter Jafo, we appreciate your presence on the program.
Thank you very much.
Thank you for coming. And that's our program for you this week. I'm Uyi Agmofwegbe. Our coverage here on ITV continues.